Hi, Billy Powers here again. Uh, I've been asked to share some things that I have done, and I'm not up to doing Zoom meetings or all of the phone calls that this might take. And no, I'm not able to help you individually. All of my documents that I've filed are on the land records. They're um, easily pulled up in Orange County, California, um, under my name, Powers Billy, and it'll show the documents filed on my property. So anyhow, I just want to make sure you know that that's available to you as well. My website, abolishthebankers.com, also holds all these documents in links. So you can go and view them, see how I wrote them. But what I'm talking about today is filing risk management claims, notice of defaults against the very parties of which are liable to you. The courts aren't helping, but public record will help you. So you're building a file, you're throwing everything, including the kitchen sink that you know has caused you harm. And here's what I did. I'm going to read it. It's also in the description for you, but I'll try my best to follow this. By the way, this is my second shot at this. I confused myself and said everything backwards. So that's why I'm reading it now. So let's read this. Okay. Number one. First, and think about this. Risk management claims, title insurance claims, these can all be handled the same because I did them all in unison. Then when Johnny Depp's case was going on with Amber Heard, it came out that her insurance company, her homeowners insurance, declined further payment to her attorneys. So when she filed this case against Johnny Depp, her insurance company was paying her homeowners insurance. Start thinking outside of the box, folks, because that's the reason I found this technique. I thought, well, how can I do this? And this is what I came up with. I consulted those who have done paperwork in the past, took great notes, and here's what I ended up doing thanks to the help of those who know more than me and who showed me a path. First of all, show your evidence. Put an affidavit together, an affidavit in jurat, meaning you jurat it. You don't just affidavit, you jurat it. You're attesting to everything inside that document. You're signing it under the penalty of perjury. And if you have any facts and evidence at that time, attach them. Don't exhibit, attach. Make it part of your affidavit. It becomes part of the document. And you send these facts to the parties you claim are harming you. You do a notice of liability, and you attach a waiver of tort. And there you list everything you believe they owe you, why they owe you, how they can settle this matter. Like for me, when I sent it to Bank of New York Mellon, I remember in it putting, it was to part of it. Well, aside, and again, I'm sorry, I get confused, but part of what I did was I made sure when I sent the notice of liability to then Nationwide Posting and Publication, First American Title, I let them know that why they damaged me was because they were putting false claims upon the record without showing my claims of the fraud. It was very detailed, but again, you can find this all on my website, abolishthebankers.com. So the waiver of tort, which is great about this, is Becky showed this to me. She and Christina Winsey used to do a show about sovereignty back in the day, and Becky created this waiver because of something that had happened with a family member of her, and this is how she knew they worked, or at least they gave public notice effectively and lawfully. I put the waiver of tort is where you show them how much they owe you, why, and not why. We're showing, it's kind of like putting together a bill of lading almost of why they owe you this money, okay, and how much it is. You attach that waiver of tort to the notice of liability. Then what you're going to do is you're going to send this to those parties. You're going to, who you believe have harmed you. You're doing this peacefully. All you're seeking is remedy, and you want them to know, hey, it appears you're harming me, you're damaging me, and this is what I see. And I'm going to give you 30 days or 15, whatever you're going to give. I gave 30 days to respond, I believe. It may have been 15, but I think it was 30. And you tell them that, and you also put in there that silence by acquiescence is guilt, and you will move forward, and you are going to be then known as the party who has the ability to take over and do things on the land records for what they have not answered to or what they've done to you. Hopefully, when people get these, the hope is that they're going to answer and say, how can we fix this? Oh, you're right. That wasn't good. But we know now, after 16 years of doing this, I can tell you, the big attorneys and that don't care, because they can lie their way out of all of this in a court of what used to be law, because that court is so corrupt and they're all changing monies behind the scenes. You don't stand a chance, and you're spending a fortune. So this is something you can do that won't cost you a fortune, that'll put on the record. 1, show your facts and evidence, create your affidavit. Get it notarized under jurat. 2, send that notice of liability with the tort of waiver to the parties harming you, and CC everybody. Send it to everybody. Let them know you've given this notice. The attorney general, the district attorney, the sheriff, all parties, that whoever you want to. Why not? Give everybody notice right now at this point, okay? Because right now you're just telling everybody, I've been harmed and I'm seeking, as an honorable person, peacefully seeking help, taking care of these damages. Okay, got the notice of liability. You send it off to all of them. I sent through the mail and made sure to certify mail this, okay, so that you have a tracking that you've done this. So you want a lawful tracking, you've done this. Then after this time, if there's no negotiation and if nobody's helping you, then what you're going to do is you have to run a 3-week notice in the newspaper. Now, check your states and laws and county and all that. Make sure you're doing all the time frames. Ours was 3 weeks, so I had to run it for 3 weeks in a legal public notice, okay, in a legal publication. Got that? So do that, and after 3 weeks, now you have said, you've sent them a notice, they didn't answer. Now you've put in the public realm that they didn't answer, and they have 3 weeks still before you're going to proceed. Okay, so they don't answer, which is what happens. And so after 3 weeks, then you have the ability to file a notice of default on that action. And what I did was I created a notice of default. It took me many attempts before I was successful. So don't give up. Don't let people tell you no. Problem solve. And I problem solve by going directly to the rules, written rules, not just their verbal no's, but to the written rules of publication, to the written rules of land records filings. Okay? These clerks will tell you they can't take things. Yes, they have to, and you can show them why. Ronald Gillis, a dear friend of mine, he and his wife, Debbie, Ronald and I have known each other for years, and Ron actually was here recently, and I helped, I rode along with him. Gosh, it got me out of the house, and it was nice to see him. And we went and delivered some notices, and it was wonderful to spend time with them. And hey, if this is what we have to do to see each other, so be it. But do that. You want to create a record trail, your record trail, showing that you've done everything you can. So what I did is I created a notice of default that had to be tweaked many times to follow the guidelines of which they had to take it across the counter and couldn't tell me I had done something wrong. I attached my juratted notice of liability, my proof and evidence that I talked about for the damages, everything that I had put in that notice of liability with the jurat, and a cover sheet as a notice of default with that as an attachment. That became part of my notice of default. So these were not removable from the notice of default. They're still on the record and it's still there. Okay. And then, so you file the notice of default, you give the 90 days, whatever requirements are wherever you are. And after that 90 days, you have the ability to do a trustee sale yourself, foreclosure sale, sheriff sale, whatever they want to call it. You have lawful standing. And in my opinion, based on what I've done, this is what I'm saying. Now, you may find something different, but I sent all of this to a trustee company. And if all of you who are listening know who your trustee company is, can you imagine hiring them to do the same thing against the parties that damaged you? Because guess what? The title company told me, I was called back and I was told, I asked, well, and they said, well, you've done everything right. Okay, well, I'll take their word for it because I don't hear that often. I mean, usually it's attempt, and either fail or succeed. So apparently I succeeded in this. Prior to filing this, I had 2 years ago, now this has all been done since 2013-14. My education in this started in about 2011. So by 2014, I felt confident enough to do this. And believe me, you do need confidence because you better stand on your knowledge and who you are. You are who you are. That's it. And you have the right to put claims upon the record of your land records. Linda Nash of Nash versus Bank of America, she's got a wonderful page, homeownerslegalrights.org, homeownerslegalrights.org. She talks about all this. She talks about the Northwest Territory Ordinance of I think it's 67. But anyhow, it's there. So anyhow, that's where I sit today. I filed in 2020 a criminal claim after I sent a claim to the IRS Criminal Division for the tax evasion being committed with the use of my identity. This is identity theft, Social Security theft, title theft under a sophisticated real estate fraud scheme perpetuated by the dirty hands of those evading taxes. That's how I put it together. Again, you have to remember foreclosure and the taking are your damages. The action is the crime committed that caused those damages. And tax evasion is a crime. Plain and simple. I was contacted by Orange County District Attorney John Menn, real estate fraud investigator. He opened a case. I literally took a plastic bin with 7 binders, the first one detailing my claim, the other 6 supporting my claim, knowing that thousands of documents more are available. Since filing that notice of default, since an alleged trustee sale in 2016, my identity has continued to be used for identity theft, Social Security number theft, title theft, while an account is still open billing the identity. Select Portfolio Servicing is still billing. Now, in February, a broker, Julie Bruckner, held an illegal trustee sale, not an illegal trustee sale. She knew I had claims of an illegal trustee sale and that the account was still open. She admitted that my property was landlocked. I'll go into that on another detail. But what I'm telling you is, because I have done all of this prior, because I sent notices, cease and desist, filed notice of defaults, they're all on public record. Title insurance goes back to when you purchased the property. When I purchased the property, I can sue, and I did for breach of contract, based on landlocked property, forged grant deed, and yes, I failed at that attempt. Remember, attempts you can do over and over. But no one now can remove these documents from the record because they were done lawfully. My Claim to you is, don't spend so much time suing. Spend time pursuing your insurance claims, of which you may not get the millions based on the RICO is treble damages, but your claims on the record, they're still there. And my claims on the record were omitted intentionally off of title. February 15th closed escrow with the broker and real estate agent, Julie Bruckner, well aware. Renee Weiler called her, spoke to her. She pretended not to know that she had had no notice. Oh, I don't know anything. No, we know she did, because what did I do previously? I sent cease and desist. I sent all of this information, certified mail. The district attorney has it. She's been CC'd with the district attorney. So don't lose hope. Don't lose hope. The Beach family took them 100 years to get their property back. Now, you and I may not be here 100 years from now. Who knows? Maybe Musk is going to come up with something and government has to disclose we're going to live forever. Who knows? Go to another planet. At this point, I think most of us would prefer to be on another planet, because this one has become so corrupt. And they're stealing our land. But guess what? That our land, that's our land. It's your land. It's your home. It's your title. Title cannot pass by fraud. Take the time. Don't sue, pursue. Know your case. Do the simple 5 steps. Now, I say simple because I've done it and it's been there. It wasn't so simple for others, because you have to really take the time to comprehend what you're doing, read about it, and don't expect everybody else to do it for you. I can't do it for you. I had to give it up. I'd have a stroke, literally, if I had to do another series helping people, because I've come to believe people are stupid and ignorant until it happens to them. And then once it happens to them, they demand someone else help them and do it for them. We can't do it for everybody anymore. After 20 years, you've got to take these steps yourselves. I learned. I created based on the knowledge that was handed to me to learn from. So please go out, think about it. Don't sue, pursue. Don't feed the courts, but feed your land records, your claims. Stake your claim, put it on the land record. Okay, folks, please get some work done yourself and let's get our lands back. Title can't pass by fraud, right? Title cannot pass by fraud.